Welcome to UCounsel. This is our fifth and last lecture on this topic. We started the discussion by posing a question whether tort liability could arise from a virtual misconduct. We went through this discussion in detail in our last four lectures. We gave you some examples of virtual misconduct that occurred in reality in the last few years, and we talked about what could be damages that may arise from that virtual misconduct. Could those damages be considered real? And whether a duty of care could genuinely arise from such virtual misconduct. And in last lecture, we went through all of the steps in figuring out whether a tort liability may follow from a virtual misconduct. In today's lecture, assuming that there is potential tort liability, in today's lecture we'll talk about some of the defenses that could be raised to defeat a claim in tort liability. We begin with our usual disclaimer that this lecture is not legal advice, so if you have any specific questions regarding your issues, you should contact a lawyer or a paralegal or the Law Society of Ontario for any referrals. The most common defense that will be raised in tort claims, as always, is contractual waivers. We'll explain that briefly, what kind of defense that is. In the United States, there's also the defense under First Amendment for these kind of claims that may be raised. In Canada, Section 2 of the Charter can be raised, which provides protection to expressions. And then there may be some additional statutory protections in the United States that we will cover today. Contractual waivers is the most common defense. And the defense may apply with respect to third-party materials, third-party conduct. The defense may apply in the sense that it may be argued that you use whatever activity that you are performing at your own risk, so the risk is downloaded onto you. And then there may be a broader category of no responsibility or complete waiver of any activities within the contract. We sign these waivers all the time in all kinds of activities, whether you go for skiing or skating. You're given a document which is a contract, and you have to sign it. So for you to be allowed to do skating or skiing in that arena, you're required to sign that waiver, and that waiver may have specific clauses that will indicate what kind of liability is waived by you when you sign that waiver. Now, in our case, let's take the example of Roblox. We talked about Roblox as an example of some of the cases that we have described. We talked about that 7-year-old who was groomed to send his sexual images to others through third-party material. And so what does Roblox say with respect to third-party material? If you go on their website, with respect to third-party material, you will see this contractual waiver, which says you agree to use the service at your sole risk, and that we shall not have any liability to you for content that may be found to be offensive, indecent, objectionable, inaccurate, incomplete, untimely, invalid, illegal, of poor quality, or otherwise. So pretty broad clause there, which protects all kinds of things arising, all kinds of misconduct that may arise from a third-party material. In our example, it was a third-party communication app that the child had used, not owned by Roblox. And so this particular clause would protect, or at least Roblox would argue, that it is protected from any liability because of this particular clause. Now, Roblox also has a very broad no responsibility clause, which is all in bold. You assume all risk for any damage that may result from your use or to offer access to the service. You're dealing with any other user of the service or any other material or content available through the service. So pretty broad, again, a clause that protects Roblox from any responsibility. So what will happen in a scenario where, for example, Roblox or another game provider is sued under as liability for tortious conduct, virtual misconduct of another user? They will bring up these contracts which are on their website, and these are essentially the terms of the use. So anyone who is using Roblox essentially agrees to these terms, and that is how that person is allowed to use that game. So they will come up and they will say that, look, we have this clause that protects us from liability, and therefore, no, even though you find that there is a valid tortious claim against us, because of this contractual waiver, there should not be any liability assigned to us. And so this kind of contractual waivers are used all the time in tort cases. Now, whether the court will agree to enforce that contractual waiver is a separate discussion, and I think I'll post a separate lecture on contractual waivers alone, just so that you have an understanding of what are those circumstances when these contractual waivers are actually enforced and when are these waivers not enforced. Because like me, many of us would not have even read these kind of waivers, and yet when we check that box and say we agree to this waiver, then to what extent are we held accountable for our acceptance of that terms of service, right? So that's a separate discussion. We'll have that in a future lecture. Now, in the United States, First Amendment, it has been and will be used by virtual providers and virtual users as a defense for any tort liability. Now, there was a case back in 1969 called Stanley versus Georgia, and that case, Mr. Stanley was charged for possessing obscene material, pornography, and so the case all the way went to United States Supreme Court, in which the U.S. Supreme Court held that makers of Constitution sought to protect Americans in their belief, thoughts, emotions, and sensations. So this is a bit more, we can say that this is not just an expression, it is more than expression. Beliefs, thoughts, emotions, and sensations are all protected under First Amendment. And so the virtual world providers may argue that the fantasy world of virtual reality is also similarly protected under First Amendment. So this argument, I believe, will definitely be advanced. There was another case in 1974 called Spence versus Washington. It also went to United States Supreme Court, and it resulted in a test called Spence test. And in that case, a student was charged. He displayed an American flag upside down with a peace symbol affixed to it. And the case went on to U.S. Supreme Court, and the U.S. Supreme Court had to decide whether that particular act of displaying the American flag upside down with a peace symbol was that an expression, and if it was an expression, whether it was protected under the First Amendment. And so the court held that an intent to convey a particularized message was present in that instance, and in the surrounding circumstances, the likelihood was great that the message would be understood by those who viewed it. So essentially, it turned into sort of two-part test later on, whether there was a particular message present. So, whatever expression we're talking about, does it have a message? And would generally people understand that to be as a message? So those are sort of the two-part test. But that will also be applied in virtual worlds, whether the content of the virtual world is an expression, and if it is an expression, whether it's protected under First Amendment. Now, most recently, this sort of came into U.S. Supreme Court in 2011 in Brown versus Entertainment Merchants Association, and in this case, it was pretty much on topic, because it dealt with a violent video game, and whether that those video games could be sold to children without their parental supervision. There was a California law that actually banned it, and so that was challenged, and it went all the way to U.S. Supreme Court. And what did the Supreme Court say? They basically struck down the law, and they said, like the protected books, plays, and movies that preceded them, video games communicate ideas and even social messages through many familiar literary devices such as characters, dialogue, plot, and music, and through features distinctive to the medium, such as the player's interaction with the virtual world. That suffices to confer First Amendment protection. So, based on the laws, on the cases in the U.S. Supreme Court, it will most certainly be the case that the companies like Roblox and others, and users who have been sued for the tort of negligence for their misconduct, they will bring this First Amendment argument through these cases to avoid liability of tort of negligence. Now, Canadian Charter has Section 2, which protects expression, but in Canada it's a bit different. In Canada, expression is not an absolute right in Canada, and Section 1 allows certain limitations on that right. And one common example of this is hate speech, that hate speech is not a protected expression. And what court does in Canada is it weighs the rights. It weighs what is the harm. So in case of hate speech, what is the harm that it causes to society or to people or to certain people, and then what is the harm, on the other hand, what is the harm if you restrict that expression? And so that's sort of the exercise that courts in Canada do to determine whether a specific right is protected under Section 2 of the Charter. But in Canada, this argument will come into play. There could be some statutory protection. Certainly in the United States, there's something called Communications Decency Act, and there is Section 230 of that act, which says no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So essentially, under this section, a virtual reality operator provider would argue that they're not liable for the misconduct of their users. So in essence, what we have done in all these 5 lectures is we have, as I said, this was an exploratory discussion. We believe that these cases will come to court, most certainly come to court, and this issue will be explored in more detail. Virtual reality and the real world will collide, and the courts will have to grapple with all of these issues about duty of care, about the reality of damages, and whether the court will apply the waivers, and whether the virtual reality conduct will be protected under First Amendment in the United States. All of these will be subject of great discussions in the coming years, and we will be surely watching these, and we'll bring you news if we find any cases that come to the courts and are decided. Thank you for watching and participating in this discussion.